Today we will be discussing the competence to consent to a search and seizure. My name is Amanda Koff. Contents will include the Fourth Amendment to the Constitution of the United States, adjudicative versus decisional competence, mental health and the competency for consent, and research studies which include Cage-Hero, Lichtenberg, and Nadler. We will also look at three cases: Schneckloth versus Bustamante, Caniglia versus Storm, and State versus Fincher. We'll also be following up with several discussion questions and references. First, let's take a look at what the Fourth Amendment to the Constitution of the United States states. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Let's discuss the two main competences that are prevalent in legal proceedings: adjudicative versus decisional competence. Adjudicative competence is a legal standard determining if a defendant has the mental capacity to understand the legal proceedings against them and to participate in their own defense. Decisional competence is the ability to make an informed, rational decision by understanding relevant information, appreciating the situation and its consequences, and reasoning through the options to communicate a choice. It's important to discuss how mental health affects the competency for consent. Legal and mental health professionals agree those suffering with mental illnesses are more prone to involuntary consent to searches and seizures due to several underlying factors. One being they are accustomed to complying with authority figures in their lives due to relying on help of someone in a supervisory role. Another factor being some individuals with mental illnesses will seek to please others and may be unequipped to process confrontation. And depending on their disability, individuals may be easily deceived or coerced by others. The Supreme Court adheres to a policy that the search validity relies on whether an officer would have believed that the individual was capable of voluntarily consenting given the information they possessed at the time. This can be problematic given that they are usually untrained and inexperienced in identifying and communicating with those suffering from mental illnesses and impairments. According to B.L. Hernandez, 2014, because of this, the Supreme Court has left the Fourth Amendment rights of many defendants suffering from mental illnesses unprotected, contributing to the growing overrepresentation of the mentally ill within the populations of the incarcerated. Now, let's look at a research study by Dorothy K. Cage-Hero. A study was conducted by Dorothy Cage-Hero where search scenarios were simulated using two different approaches when trying to obtain voluntary consent to a search and seizure by a legal official. The study concluded that consent was given more freely when approached using an interrogatory method versus a declarative method. An interrogatory method example would be, "Would you mind if I conducted a search of your house, car, or person?" A declarative method would be, "I would like to conduct a search of your house, car, or person." The study also found that more information the legal official offered, or the better they explained the situation, the higher probability of voluntary consent. Now let's discuss a research study by Dr. Peter Lichtenberg. A study conducted by Dr. Lichtenberg surveyed 54 individuals that had reportedly consented to legal officials. The investigation discovered the primary reason consent was given was due to a fear of what would happen if they refused. Furthermore, the individuals felt the law would not be followed, nor would their rights be protected should they refuse. According to Melton et al. 2018, the contributing factors mentioned in guiding their decisions were the number of questions asked by the legal official, the feeling of being rushed, and the individual's education or employment level. Finally, let's look at a research study by Janice Nadler. A study conducted by Janice Nadler regarding consent cases concluded two main factors. Did the consent to search lack sufficient voluntarism? Was it given under duress? Had the individual who consented to the search been seized unlawfully? The answer is multifaceted in that it relies on the demeanor and language of the officer, the circumstances of the situation. Was it a traffic stop, or was it a bus or building sweep? And the knowledge of the individual's ability to refuse a search and seizure at any time. The study also concluded that many individuals didn't feel free to decline the search request or terminate the encounter due to negative consequences. Next, let's dive into some cases surrounding consent for search and seizure. In Schneckloth versus Bustamante, Robert Bustamante was a passenger in the backseat of a car when he was pulled over for a missing headlight. Being the only passenger who was able to provide identification, he was asked by the officers for consent to search the vehicle, to which he agreed. Stolen checks were discovered during the search, and he was subsequently charged even though it was not his vehicle. The case went to the U.S. Supreme Court, where the respondent argued the search and seizure was involuntary because he was not made aware of his right to refuse. On May 29, 1973, it was ruled, among a dissent from Justice Thurgood Marshall, the consent was voluntary, given a quote-unquote review of the totality of the circumstances, and no constitutional rights were violated. It was further ruled that while the knowledge of the ability to refuse a search is to be considered, it is not required, nor does it invalidate voluntary consent. Next, let's look at Caniglia versus Storm. The morning after an argument with his wife, Edward Caniglia was visited by officers after she had expressed concern that he might have committed suicide. The officers found Mr. Caniglia well, but as a precaution convinced him to go to the hospital for a psychiatric evaluation. After he was taken to the hospital, the ranking officer confiscated 2 firearms from his residence without a consent to a search and seizure, citing, quote, community caretaking, end quote. Mr. Caniglia was evaluated but not admitted, and after several failed attempts to have his firearms returned, he filed a lawsuit stating they were taken against his Second and Fourth Amendment rights. The U.S. Supreme Court agreed, setting new precedents that private homes required more in terms of consent than a vehicle or person in regards to, quote, community caretaking, end quote. Finally, let's look at State versus Fincher. In the case of State versus Fincher, the North Carolina Supreme Court ruled that the defendant was competent to give consent to a search of his room, even though a psychiatric evaluation had deemed he suffered from mild mental retardation, schizophrenia, and hallucinations. The defendant was 17 years old at the time with an IQ of only 50 to 65 when he was told by 10 police officers if he didn't give consent, they would be back with a warrant. Psychiatric testimony stated Fincher, like many who suffer from mental illness, was more susceptible to fear and given such was less likely to decline consent, making the search invalid due to Fourth Amendment. Now let's go over some discussion questions. Watch the brief video linked below on the Fourth Amendment explained, then answer the following questions. Do you feel a legal official should be required to state your right to refusal when requesting a consent to a search and seizure? Why or why not? Do you think there should be a field competency test, similar to a field sobriety test, given when requesting consent to a search and seizure? Why and why not? That includes our presentation today around the competency to consent to search and seizures. I appreciate you taking the time to listen to this, and I look forward to your feedback regarding the discussion questions.